This video has been brought to you by Pro Bono Students Canada's Family Justice Centre and has been sponsored by Epstein Cole, Legal Aid Ontario, and Schulman and Partners LLP. Disclaimer. This video contains general legal information and not legal advice. Please consult a lawyer for legal advice regarding your specific matter. Costs. Family Law Rule 24. In this video, we will provide an overview of how costs are awarded and determined. What are costs? In family law, cost refers to when one party has to pay some or all of the legal costs of the other party. A judge can make a court order for costs. The main purpose of awarding costs is to create a consequence that encourages settlement, partly compensates for legal fees spent, and discourages inappropriate behavior. When are costs decided? A court may decide to award costs after each step in a case or reserve the decision for a later point. For example, costs may be ordered after a hearing or at the conclusion of the court file. How are costs awarded? There is a presumption that costs will be awarded to the successful party, unless it is a child protection matter or a government agency is one of the parties. However, this does not always apply. Although there is a presumption that the successful party will have some of their legal costs paid by the other party, if they behaved unreasonably, they may receive a lower costs award or be ordered to pay the other party's costs. A court considers a party's behavior, any offers to settle made, and any withdrawn or refused offers to settle when determining reasonableness. If there is divided success between the parties, the courts may divide costs between the parties, order no costs, or award costs to the party who was most successful overall. If a party does not come to court or is not properly prepared, courts may award costs against that party. If a party acts in bad faith, the court may order them to pay all the other party's costs. A finding of bad faith requires proof that a party intended to inflict harm, conceal relevant information, or deceive the other party. If a party fails to accept a reasonable offer to settle, they can face a cost consequence. Courts may consider the terms of an offer when the offer was made, and any failure to make an offer. How is the amount of costs determined? The amount of a costs order is up to the judge in each case. When deciding this, a court will look at the legal fees the paying party thought would be spent, and if that expectation was reasonable. The court will also look at how difficult the issues in the case were, and whether any of the parties behaved badly or wasted the court's time. Finally, the court will consider if the offers to settle made by each party and their total legal fees were reasonable. In Ontario, costs are usually only part of the total legal fees spent by a party, often less than 50%. But costs may be more than 50% when a party does better than their offer to settle or when the other party behaves badly. Pro Bono Students Canada's Family Justice Centre runs virtual legal clinics that provide summary advice and document drafting services to eligible self-representing litigants in Ontario. Please visit our website to find out more about our services. Thank you for watching.